Times Newspaper Limited and Flood and the Associated Field.
Mr. Miller, before you resume, I just want to say that we may find ourselves sitting a few minutes late tomorrow morning, certainly no later than 10:15. We're due to start at 10, so we may sit a little bit later than anticipated today to make up for it and squeeze a bit of time in tomorrow, but we'll give you all your allotted time if it's needed. But I just thought I'd warn you. So treat tomorrow as not before 10, rather than at 10.
Lords, we've handed up a short note on the facts.
Thank you very much.
It was asked for yesterday by my Lord Mance. I simply have three more points or headings to cover very quickly. The first one is that even if Campbell number 2 is in conflict with MGN versus UK, we say the court must follow the Strasbourg authority now. Our arguments under this heading are in our written case at paragraphs 73 to 81, starting at page 630, volume 2, tab 5. We won't repeat them. We say none of the reasons for not following a Strasbourg decision apply here. On the contrary, MGN versus UK was a fully reasoned decision on the Article 10 issues arising. We say there was no misunderstanding of any substantive or procedural aspect of our domestic law. It was an application arising out of the House of Lords decision, which we would be asking you to depart from, and the government didn't seek referral of the decision to the Grand Chamber. This being so, Campbell number 2, we say, should be departed from. In an attempt to avoid this, we say, obvious conclusion, the respondent takes two bad points. First, the respondent is wrong when he suggests that MGN versus UK can be distinguished because the Article 10 right asserted by MGN, that is in the substantive proceedings for misuse of private information by Ms. Campbell, was, and this is how he puts it in his written case, far superior to that of the appellant in this libel case. That's in the respondent's written case at paragraph 42.1, page 653. The facts of the substantive publication case are relevant in considering who should win on liability. They're also relevant in considering what the remedy should be. They are not relevant in deciding whether the imposition on the losing publisher by a costs order of an obligation to pay additional liabilities is justifiable under Article 10.2. There has never been anything in the statutory scheme or in the government's justification for it to suggest that in a publication case this financial liability is some sort of penalty for the way in which the right of freedom of expression was exercised. Secondly, the respondent suggests that what he calls the subsequent events identified in his written case mean that MGN versus UK should be distinguished. These are recounted at great length in the written case, starting at paragraph 43 on page 654, that is the respondent's written case. We say these are irrelevant to the issues before the court because the government has never said that it has not introduced a convention-compliant access to justice scheme for publication cases, because the offending regime identified in MGN versus UK had somehow become Article 10 compliant because of these subsequent events. My second heading is ATE, which of course...
Isn't it for us to judge that, whether the same vice exists? It's for us to look at the subsequent events and decide whether it's not what the government says which matters, it's whether in fact the subsequent events do mitigate or alter the position.
Well, none of them address this issue. They are...
No, I mean, you can say that. That's a submission about the subsequent events.
Yes. Well, I've got time to go through all of them. You'll have seen it.
No, I mean,
the entire history of British media law since 2012.
Yes. You say they just don't bear. They go around the edges, if anything.
Yes. Amendments to the Defamation Act, through the Defamation Act 2013 and so on and so forth, are made for their own reasons and nothing to do with this. ATE, not directly an issue in MGN versus UK. Our written submissions on this are at 82 to 83 in our written case, starting at page 634. Again, we won't repeat these. We say that where it's incurred by a claimant as an extra slice of additional liability on top of the success fee, this only illustrates the extent to which the 1999 Act scheme as a whole is incompatible with Article 10. And of course, we stress that the two elements of additional liability have always been part and parcel of the same statutory scheme, or the recoverability thereof. And we say that as the figures in this case show, the stage premium will be a substantial further amount on top of the success fees incurred by that particular stage in the action. It's no answer to say that a media organisation can waive or limit its entitlement to claim costs in the event that it wins before ATE is taken out, i.e. to avoid the incurring of the stage premium liability in issue. It would only be doing this in a system where costs are presumed to follow the event because of the very threat of having to pay very high ATE premium if it loses. The threat is present because of the 1999 Act regime. So the possibility that this might even have to be contemplated doesn't avoid the conclusion that the legislation is incompatible with Article 10. It only reinforces it. The final point I wanted to make is simply this. These appeals are by three newspaper groups. But the court should not forget that this regime catches small publishers who cannot afford to take on claimants who have incurred additional liabilities or to bring appellate challenges like this. These include local and regional press and NGOs when publishing material said by an opponent to be defamatory or confidential, but by them to be in the public interest. These are very real problems for such publishers, and their position should be taken into account here, as it was in Strasbourg through various interventions, which you'll see in the judgment that I didn't take you to, but points were made before the Strasbourg court.
So you would say if things like the telephone hacking revelations have led to the previous scheme surviving, really that treats everyone, all aspects of the press, as one which is unfair, and there are certain parts of the press, substantial parts, which are unfairly suffering.
Very substantial parts. Yeah. Obvious proposition. It would be quite wrong to, in effect, penalise the rest of the press for those failings. I'm very grateful. Those are my submissions, unless there are any questions.
Thank you very much, Mr. Miller. Mr. Silverstone.
No submissions.
Or panel.
Lords, I appear with Jamie Carpenter for MGN. The respondents in our case are represented by Hugh Tomlinson, Simon Brown and Jeremy Reid. Lords, this appeal raises 5 issues. The first issue is the same as in the first 2 cases, whether the court should follow an judgment of the European Court in MGN and United Kingdom and find a system for recoverable success fees and the ATE premiums breaches Article 10. And I have some supplementary submissions to those which your lordships have heard from Mr. Rampton and Mr. Miller, submissions which I gratefully adopt. The second issue is whether the MGN and UK principles apply in the context of my case. The written case for the respondents contends that MGN does not apply because the conduct of the newspaper was not justifiable under Article 10, and the claimants, they say, could not afford to litigate without additional liabilities. And I want to address that. I'll submit that Mr. Justice Mann rejected the respondent's argument, and rightly so, because MGN is concerned with whether the success fee system whether the additional liabilities system breaches Article 10. It's not concerned with the facts of the individual case, so long as the success fees and the ATE premium fall foul of the principles stated by the European Court, which they do, and I'll seek to develop that. The third issue is the nature of the remedy having regard to any legitimate expectations. Our submission, in agreement with Mr. Rampton and Mr. Miller, is that it is unlawful under Section 6.1 of the Human Rights Act for a court to award the additional liabilities under the statutory scheme. We do not accept that the respondents have any legitimate expectations. In particular, in our case, they all entered into the CFAs and the ATE insurance policies after the judgment of the European Court in MGN and UK. We will say that they cannot have a legitimate expectation that a court will act unlawfully under the Human Rights Act, and I'll make some submissions on that. And the fourth and final issue in our case is estoppel. Estoppel applies only to the success fees, not to the premium, and it applies only to the success fees for the representative claimants, 8 of them. And our submission is that Mr. Justice Mann erred in law in finding that, there was an estoppel which arose because the appellant resisted a 10% uplift in damages for those 8 representative respondents. We say there was simply no basis for a 10% uplift. Now, my lords, those 4 issues arise in our case in the context of very substantial figures for additional liabilities. Can I take your lordships, please, to the core volume, volume 3, at the tab 4, which is the statement of facts and issues. And if your lordships in that go to page 929, your lordships will see at paragraph 36 the position in relation to the first 4 of the respondents, and they are separated out because they are respondents to whom the new proportionality rules do not apply. I'll come back to those new rules in a few moments, but they're separated out, the first 4 of them. And at paragraph 36, your lordships can see that subject only to the outcome of this appeal and combining individual costs and appropriate shares of the common costs, the position is that the damages total, it's not given there, but it's in fact 182,500. That's what they recovered. Their base costs are 713,000 odd. One then adds to that a success fee of 687,000 and the AT premium of 170,000. And so the additional liabilities double the base costs in their cases. That's paragraph 36.
Have we seen that?
Paragraph 37, we see in relation to the other respondents, and here, subject to the outcome of this appeal, and subject also to the post-LASPO proportionality argument in respect to individual costs, combining individual costs and appropriate shares of the common costs, at page 930 at the end of the table, one sees the total, as again, the total is not given for the damages, but my calculation is 1,529,500, 1,529,500.
Thank you.
Your lordship see the base costs are 2.8 million, and one adds on to that, subject to the outcome of this appeal and post-LASPO proportionality, one adds on another 1.78 million for the success fee and 593,000 for the AT insurance, again doubling the figure. Also, one notes in relation to these cases at paragraph 38 that in addition to that, we have to pay the costs of the detailed assessment of costs. And the reason for mentioning that is that that also carries the success fee. The appellant is also liable to pay the respondent's costs of detailed assessment, which also attracts success fees. That's being negotiated, and your lordship see the figures that are being claimed there in paragraph 38. And I mention that because success fees for the costs of detailed assessment are especially iniquitous, because the claimant is recovering a success fee on costs which by definition would not have been incurred unless the claim was successful. They are costs which are inherently risk-free, and that's what Sir Rupert Jackson said in his final report. He said he saw no justification for a success fee being allowed in detailed assessment proceedings. The reference is volume 5, tab 2, page 1403, and it's paragraph 5.25 of chapter 10 of his report. And the problem is that the court has no power to allow a different success fee for different parts of the case. So if you get a success fee of 100% for liability, that's carried over to the detailed assessment, and that's particularly iniquitous. Added to that, we have, so the total figures are then given in paragraph 39. I won't take time on that. And on paragraph 40, we also have to pay the costs of the Court of Appeal proceedings, where we appealed against the substantive judgment of Mr. Justice Mann. That was a 2-day outing in the Court of Appeal. There were the 8 representative claimants, and your lordship see the figures there. For this 2-day hearing, they presented bills for £739,000 for base costs, plus £645,000 odd for success fees, and another £318,000 for ATE premiums. The first 2 figures include VAT, and these costs are to be assessed by the senior cost judge, I understand, next month.
When you say representative claimants, that's all the claimants in 36 and 37?
There's 8 of them. It's only 8 of them. There were only
Oh,
8.
I see, it's 8 of them.
The
So
representative claimants are some of those in 36, some of those in 37.
I see. So how many counsel do they have?
Well, they had 2, in the Court of Appeal, they had 2 junior counsel. My recollection was Mr. Reed and led by Mr. Sherborne. Yes, and one aspect, I think on one aspect, Mr. Brown also made an appearance.
What, for 2-day Court of Appeal hearing with 2 counsel?
Yes.
Base costs of £739,000. Life has changed.
Well, I'm only concerned because my friends make the point, and they're entitled to make the point. The court is not here assessing the respondent's costs. They say it was hard-fought litigation. That, with respect, misses the point. My point is that whatever the appropriate base costs, and they are remarkably high, but whatever the figure...
But wait a minute, these are base costs that are claimed. They haven't yet been assessed.
No, they haven't been assessed. No, and that's the point my friends made, and I accept that. My point is that whatever the appropriate figure, it's going to be multiplied by success fees.
Yes.
And my complaint, supporting my friend's complaint, is that a statutory scheme for such additional liabilities inevitably has a very damaging effect on freedom of expression, as the Court of Appeal accepted in MGN. The additional liabilities are extraordinary sums. They are less an award of costs than a cashing in of chips in a legal casino. They are extraordinary amounts of money that are being required to be paid. Now, on the first and second issue, whether the court should apply the judgment of the European Court in MGN and UK, I have some.
And we have to be. You're saying nothing about the base costs.
In this appeal, no.
So we have to be a little careful about getting carried away with the figures, because they are not assessed yet, and B.
Well, some of them are, with respect, some of them have.
Fine, okay, but and B. the success fee and ATE premium are a function of the base costs.
Yes, my point...
One has to be a bit careful because a lot of the surprise that one might feel is based on the sort of surprise which Lord Mance expressed a minute ago.
Yes, your Lordship expressed a similar surprise
Yes.
in Lawrence,
Yes.
which again was a case where an assessment had not been carried out. One's entitled to express surprise that such figures are being claimed. That's the first point.
But
entitled to say
the
that.
other two figures are a function of that.
No, ATE isn't.
Well, the success fee is it not?
The AT premium is not a function.
Well, it's to some extent a function of that because it's related to what the costs overall are expected to be. It's not related in a precise way to the base costs.
I accept that. Your Lordships are entitled to express surprise at the amount that's being claimed.
Yes, we're
They
entitled
are
to.
subject to assessment. My point is that whatever is the appropriate figure for base costs, it's going to be doubled, and it's going to be doubled by reason of the statutory scheme. That's the point that I
Presumably the ATE premium is based on an assessment of your very modest costs, Lord Panic.
Well, I of course didn't appear,
Or-
other than in
or
the Court of
whoever
Appeal.
did.
I appeared in the Court of Appeal. Can I turn then to some footnotes to what has been said by my friends? And the first footnote I want to add is to emphasise that the flawed nature of the statutory scheme has become even more substantial since the European Court gave its judgment. And your Lordships have heard this. After LASPO was brought into force in April 2013, claimants bringing almost all types of claim cannot now require unsuccessful defendants to pay the additional liabilities. Additional liabilities only remain for publication and privacy cases and in claims in respect of mesothelioma. So, for example, if I'm bringing a clinical negligence claim, and it may be a case of a stillbirth or the death of an elderly relative, damages are going to be low. The defendant may be a public authority. They may raise Article 2 issues. The claimant can agree, either claimant can agree a success fee with my lawyer, but it's not recoverable from the defendant. The claimant has to make do with QOCs, qualified one-way cost shifting, and a 10% increase in damages. And the same is true if I'm bringing a private nuisance claim, which may raise Article 8 issues. I have to pay any success fee out of my modest damages. There are no QOCs in that context. And I say that the position is much worse than it was in 2011 because there's simply no justification for defendants in privacy and publication cases to be subject to a much less favourable rule as to additional liabilities. The European Court was particularly concerned about the impact of additional liabilities in freedom of expression cases. And we're now in the bizarre position that additional liabilities only survive in the context of freedom of expression cases. The respondents say that access to justice in publication and privacy cases is especially problematic, and they rely on the Leveson report. But Leveson did not recommend that liability for success fees and for ATE insurance should be retained in publication cases. On the contrary, if one goes to volume number 5, my lords, and at tab 9, your lordships will see the reports of, or extracts from the report of Sir Brian Leveson, page 1532. And if your lordships would turn on in that report to page 1542, Bundle 5, tab 9, 1542. It's the bottom of the page, 1542. Last line. On the other hand, it's not difficult to understand the very real dangers of a system which loads costs so heavily against defendants such that it's never economic to contest a claim and always, almost irrespective of the merits, more sensible to compromise at an early stage. The consequent and real risk to freedom of expression recognised in MGN is obvious. In recommending qualified one-way cost shifting in defamation and privacy cases, Lord Justice Jackson sought to find a balance between what might be described as the very substantial financial windfall, his words, of the system on the one hand, and the undeniable impact on access to justice by those without substantial means on the other. The recommendation has not found favour with the government. And then at 3:11, Sir Brian mentions the 10% increase in damages. And then at 3:13, we come to his recommendation. In the absence of some mechanism for cost-free, expeditious access to justice, in my view, the failure to adopt the proposals suggested by Lord Justice Jackson in relation to cost shifting will put access to justice in this type of case in real jeopardy, turning the clock back to the time when in reality only the very wealthy could pursue claims such as these. I recognise, as did Lord Justice Jackson, most personal injury litigation succeeds with the result that qualified one-way cost shifting is just as likely to cost insurers less, and furthermore the same cannot necessarily be said defamation and privacy cases. An arbitral arm of a new regulator could provide such a mechanism which would benefit the public and equally be cost effective. If such a scheme is not adopted, however, I have no doubt, he said, that the requirements of access to justice for all should prevail and that the proposals of Lord Justice Jackson should be accepted. So it's not his recommendation that additional liabilities should be retained. The government then asked the Civil Justice Council to report, which they did, and that's at volume 5, tab 13, page 1616. They recommended a form of quox. The government then consulted, that's volume 5, tab 14, page 1664. We're now up to September 2013. And in that consultation paper, the government accepted the recommendation for quox. If your lordships go in that to page 1691, at paragraph 51, some of the background is set out, the Jackson recommendation, and the reference to the government accepting Lord Justice Leveson's recommendation. There's then a reference to the European Court decision, which the government accept. The final sentence of paragraph 52, the relevant provisions in LASPO will address this. The government intends to implement them at the same time as cost protection is introduced. At 54, Lord Justice Leveson recommended qualified one-way cost shifting, similarly to Lord Justice Jackson. 55, the government has accepted the Leveson recommendation on cost protection and announced that implementation of the LASPO reforms would be delayed in defamation cases until a cost protection regime, qualified one-way cost protection, has been introduced. And 56, the government was committed to provide some form of cost protection so as not unduly to damage the interests of impecunious parties, and so it asked the Civil Justice Council to report, and it did so. So that's the position. Nothing's happened. But that doesn't avoid the conclusion, two conclusions, that the defects identified by the European Court based on the Jackson proposals with which Leveson agreed still mean that there's a fundamental breach of Article 10 by the system. And it is no answer that the government have failed to implement their own proposals. That's where we stand at the moment, and that's why the matter is before the court. That's my first footnote to what has been said. My second footnote is this, that it's common when one addresses allegations that the convention has been breached to look at what happens in other contracting states. And it is quite remarkable that the only legal system which appears to have additional liabilities is England and Wales. We draw attention to what the European Court said in MGN. If your lordships go back to MGN, it's volume 12, it's tab number 3, and the relevant passage is at 4839, paragraph 112 at page 4839, volume 12, tab 3.
Yep.
Where the European Court note in relation to CFAs, they say in the second sentence of 112, in relation to CFAs it noted, this is Jackson noted, that England and Wales differed from all other jurisdictions in having success fees paid not by the lawyer's own client, but by the losing party. And that is a reference to the analysis by Jackson, which your lordships can find, volume 5, tab number 2, and the reference is 1384. It's Jackson paragraph 1.9 of chapter 10. Volume 5, tab 2, page 1384, 1.9, where Jackson, Sir Rupert says, it's the fourth line, this reform set England and Wales apart from all other jurisdictions. And he refers to the report by Professor Stefan Vogener and others of Oxford University. And they'd undertaken a massive review, as Sir Rupert calls it, of the cost rules of 33 overseas jurisdictions. They have not found any jurisdictions under which CFA success fees are recoverable from opposing parties.
That, presumably, would have been a review which would have encompassed, not necessarily like a survey of European countries, a number which have reasonably well-developed costs-shifting systems.
Well, it covers, for example, Australia and Canada.
Quite.
And countries like that. Indeed, the position in Australia and Canada, if your lordship's interested in it, is set out in the House of Commons Culture, Media and Sport Committee report. I won't take the court to it, but I'll give you the reference. It's volume 5, tab 5, 1468, at paragraph 296. That's the position in Australia, Canada, and indeed at Scotland. Scotland and Northern Ireland were also mentioned in the Campbell case, Campbell and MGN in the appellate committee by Lord Carswell. Again, I won't take your lordships to it, but it's paragraph 53 of the speech of Lord Carswell, volume 6, tab 8, 2090. And our understanding is that it is still the case that in Scotland there are no additional liabilities. There was the Taylor report, was the equivalent of the Jackson report, and it records that success fees under Scotland's equivalent of CFAs cannot be recovered inter partes, nor can ATE insurance premiums. In Northern Ireland, CFAs are still generally unlawful. There was a proposal in 2015 in Northern Ireland that they should be made lawful, but without recoverable success fees. My lords, the point is this: it is impossible, in my submission, for the respondents to sustain an argument that access to justice requires additional liabilities when every other legal system appears to manage without additional liabilities. It is true that costs in this country are particularly high, but that's another question altogether.
Well, is it? Is it another question altogether? We have a different system. We have much more left to the lawyers and rather than the judges. Our legal costs do seem to be substantially higher, and if costs are a problem about access to justice, it's perhaps unsurprising that something's done about it here when it's not seen to be so necessary in other countries.
Well, the answer I put to your Lordship's question, I don't represent the Bar Council or the Law Society, is that one solution is for the government to take action to ensure that costs are not so high, whether by imposing caps on the amount that can be claimed in costs or otherwise. But it simply is not good enough for it to be said, well, we're different from everybody else. when the impact of additional liabilities is, as stated by the European Court, to have a real impact on freedom of expression.
Has the government gone some way towards this by cost management, budgeting arrangements now? Didn't apply to these cases, presumably.
Cost management and budgeting are relied upon by the respondents, but they don't apply to additional liabilities.
Well, they do indirectly.
They do indirectly. They cut down.
They don't apply to after the event premium, of course, but they do indirectly.
Well, they do apply to the off-the-event premium in the sense that that's lower because the overall cost liability will be lower.
They don't address the substance of the criticism, which is that whatever the appropriate base costs should be that you are liable to pay, you shouldn't have to pay an extra chunk on top, which doubles whatever the base costs are. That's the criticism. That is the point. And the objection, and it is not the case that Sir Rupert Jackson, or indeed Sir Brian Leveson, said that those reforms are sufficient to address the problem. The problem, according to Sir Rupert, can only be addressed and properly addressed by abolishing additional liabilities and introducing qualified one-way cost shifting and giving a 10% increase on damages. 10% increase occurred, qualified one-way cost shifting has not occurred. So that's the...
How does that work, qualified one-way cost shifting? Is that something which is predetermined? You say it's part of the cost budgeting or management, is it at a certain point?
Well,
or is it
on the basis that in assessing the amount of costs for which the losing party is liable, the court takes into account the financial resources of the losing party.
right?
Yeah. Yes, that's how it works.
Of the losing claimant.
Of the losing claimant, yes, yes.
And
Sir Rupert...
remembering that in the days when legal aid was provided to such people, there was no cost shifting.
That is true. That is true.
But when's it done? Is it done in advance or done after the event? Do you have to speculate as to what will happen?
Right. Well, it's only done in relation to personal injuries at the moment.
Yeah.
And there's no reference to means in qualified one-way cost shifting. So it's just automatic.
Subject to excess.
I see. Yeah. Yes. Well, that wasn't Sir Rupert's proposal. Sir Rupert's proposal was by reference to Section 11 of the Access to Justice Act, which was the legal aid provision that you
Right.
account.
But the present provisions are where? Somewhere in the Section 40s of LASPO? No.
Section 2 of the CPR. Part 44. Part 44.
Part 44 too. Thank you.
So that's the second of the matters that I wanted to draw attention to. The third of the footnotes that I wanted to raise was the just satisfaction judgment. Your Lordships asked a question yesterday about the way in which the European Court assesses costs, and here I can't provide an answer. I can't work out precisely how they arrived at the figure that they did. If your Lordships go back to tab number volume 12,
Tab 2.
tab number 2.
Yeah, 480, yep.
And your Lordships may have seen that the problem for the European Court was that there'd been a settlement of the costs at domestic level, and therefore it was not easy to identify what proportion of the costs were due to the success fees. And the European Court dealt with that at page 4802 in volume 12, tab 2. And at paragraph 14, in this respect, as to what element of the global settlement figure represented success fees, the court set out its own conclusion at the principal judgment. And then under the quote, the court went on to find, therefore, that even if it was not possible to quantify with certainty the precise amounts paid by the applicant which could be attributed to success fees, it was evident the negotiated cost settlement reflected the obligation on the applicant to discharge substantial success fees, which the domestic law had fixed at 95% for the solicitor and 100% for the counsel of base costs. While the success fees were calculated as a percentage of the base costs of the first appeal were not reviewed by the judicial taxing officers given the intervening settlement motivated by the applicant's MGN's desire to avoid accruing interest. There is therefore a large element of uncertainty as to the reasonableness of the base costs on the first appeal and consequently of the success fees calculated thereon. The government argued that the principal judgment did not exclude that a lower success fee might be proportionate, the argument being the applicant did not have to be reimbursed for all of the success fees, but only that part that could be considered proportionate. However, the court's findings concerned the circumstances of the present case in which success fees at 95% and 100% were chargeable. So it would be speculative to assume the level, if any, at which a success fee could be considered proportionate. As to how they worked out the specific figures, I can't assist your lordships. I can't work it out either. That's the third footnote. The fourth footnote on the first 2 points is that the respondents rely on the new proportionality rules for assessing costs, and I've made a submission a few moments ago on that. In particular, there is a dispute which is the subject of a pending appeal in the Court of Appeal on whether, and if so how, the new proportionality rules apply to additional liabilities. That is pending in the Court of Appeal. And our position is that your lordships do not need to address that issue. And the reason why your lordships do not need to address that issue is because, as this court explained in Lawrence, it was paragraph 29 and following, agreeing with what Lord Hoffman had said in Campbell in the appellate committee, that was paragraph 23, it is important not to confuse two different meanings of proportionality. That is the test of proportionality under the Convention and the meaning of proportionality in the CPR in relation to the assessment of costs. And therefore, even if, which is in dispute, even if the new proportionality rules do apply to additional liabilities, and the respondent's position is that they do not, but even if they do apply, a cost system which includes additional liabilities, we say, fails the Convention test of proportionality for all the reasons that the European Court identified and which we have sought to supplement. That's our position in relation to the new proportionality rules. The respondents, this is my fifth footnote, the respondents also seek to rely on the recommendation in the Leveson report for an independent self-regulatory system for the press. They rely on Section 40, controversial Section 40 of the Crime and Courts Act. They draw attention to that, paragraphs 57 to 60 of their written observations. And your lordships will know, since the 25th of October 2016, there is an approved regulator, Impress, and the respondents say this alters the balance of factors which were assessed by the European Court in MGN. My lords, there's no substance in that point. First of all, Section 40 is not in force. It only comes into force if and when the Secretary of State decides to implement it. Your lordships may know the Secretary of State has been consulting on whether to bring Section 40 into force. The consultation ended on the 10th of January. She may or may not decide to bring Section 40 into force, unless and until she does so. The respondents' points under this head are simply academic. Secondly, in any event, the Secretary of State had no power to bring Section 40 into force until the PRP, the recognition panel, recognised and approved regulator. Section 40, subsection 6 says that. It's volume 4, tab 11, page 1122. That only occurred on the 25th of October last year. Even if the Secretary of State were now to bring Section 40 into force, it would be quite irrelevant to the claims in the present case. All of the relevant costs were incurred, or well, the vast majority of the relevant costs were incurred before that date. And thirdly, in any event, Section 40 itself says nothing about additional liabilities. The government has recently confirmed in the consultation paper that whether to implement Section 40 will have no impact on the LASPO reforms. Can I show your lordships why I say that? It's volume 5 of the materials. And it's at tab number 15. And this is the page 1702. This is the recent consultation on whether to implement Section 40, launched on the 1st of November last, and consultation responses were required by the 10th of January. And the Secretary of State has announced there's a judicial review of this process, and the Secretary of State is waiting for the result of that before she gives her answer on whether to implement Section 40. And at page 1717, paragraph 50, the consultation paper under the heading Reforms to Conditional Fee Agreement says that Section 40 alters the cost rules in terms of which party pays the legal costs. It does not affect how a case is funded. The reforms to no-win, no-fee conditional fee agreements under LASPO do not apply to defamation and privacy proceedings. The coalition government accepted Sir Brian Levison's recommendations that the LASPO reform should not go ahead for these cases without a regime of cost protection to protect poorer claimants from adverse costs. Whatever decision is made on the future of Section 40, it will not of itself have any impact on the possible implementation of the LASPO reform. So it's not going to make any difference to whether LASPO is introduced. That's the government's position. So Section 40 is quite irrelevant. If it matters, and for good measure, I should add there's also a judicial review of the decision of the PRP to recognise impress, and that is pending. In relation to ATE premiums, it is correct that the European Court and indeed the Appellate Committee in Campbell were not concerned with ATE premiums. As I understand it, Ms. Campbell did not have ATE insurance. But we agree with the submissions made this morning by Mr. Miller that the principles in Miller must apply, in MGN, the principles in MGN must apply equally to AT premiums. And I don't think, I'll be corrected in due course if I'm wrong, but I don't think that that is seriously disputed by the respondents. The MGN judgment was founded in substantial part on the chilling effect which excessive liabilities have on freedom of expression. Your lordships have seen MGN at paragraph 201. And Sir Rupert Jackson described the recoverability of ATE premiums as one of the aspects which made additional liabilities, I quote, the most bizarre and expensive scheme that it is possible to devise, unquote, for achieving cost protection for claimants. That's what he said. And the European Court set that out at paragraph 114. The quotation is from his report, volume 5, tab 3, page 1413 to 1414. It's paragraph 3.8 of chapter 32.
So what were the page references again? One.
In Sir Rupert Jackson's
Yes.
report, it's volume 5, it's tab 3,
Yeah.
pages 1413 to
Yes.
1414.
Yeah.
It's paragraph 3.8, chapter 32. And it's set out by the European Court at paragraph 114. So the European Court were plainly aware of that. Had they been asked to address ATE premiums, I submit that there can be no serious doubt that they would have adopted the same approach as they did in relation to success fees. The respondents make a point, it's paragraph 74.3 of their written case, that the problem is mitigated, they say, by the availability for newspaper defendants of ATE insurance. They say, well, defendants can take out ATE insurance and indeed can take out a CFA with success fees. This is very problematic in practice. Lord Clark, in his dissenting judgment in Lawrence, it's paragraph 118, made the point, and with respect he's right, if the claimant had ATE insurance, which meant that his chances were better, usually substantially better than evens, the defendant would have little or no prospect of obtaining ATE insurance because his chances are unlikely to be so rated. That's the point. I mean, it's true, of course, that different lawyers may take a different view, but in principle...
Eternal optimism.
Yes, but it is unlikely that is so. And indeed, the economics of insurance for the defendant are very different. The insurer of the claimant is not relying on success at trial to avoid paying out. In fact, the last thing that the insurer wants is a trial. It wants a settlement, because it knows that any settlement is likely to involve payment by the defendant in this type of case of the claimant's costs. By contrast, the insurer of a defendant knows, not invariably, but in the normal run of case, the insurer of a defendant knows that a settlement will almost always involve it having to meet the defendant's costs. And indeed, any insurance policy for a defendant would also involve the provision of an indemnity in respect of the claimant's costs as augmented by the success fee and the ATE premium. Then, if the defendant has a CFA and ATE insurance, the claimant is going to need to increase his or her level of indemnity to cover that risk, as the unsuccessful claimant would need to pay the successful defendant's success fee and ATE premium. And this could go on ad infinitum. Our case in relation to this is that if recoverable success fees and ATE premiums are objectionable, it cannot be an answer that, in theory, the defendant could protect itself by entering into similarly objectionable arrangements, which are going to make it even more difficult for claimants to get access to justice. Claimants are going to regard these arrangements as possessing all the same vices, pressurizing them to abandon good claims for fear of the cost of losing. So we say that there's no substance in this as somehow resolving the problems which the European Court identified. And for all those reasons, on the first point, we support the submissions of Mr. Rampton and Mr. Miller that MGN should be followed and it should be applied. I turn to the second issue, which I identified as whether these principles in MGN and UK should apply in the context of the present case. And your lordships will have seen that the respondents say that the MGN publications were not protected by Article 10 because they were serious invasions of privacy which had no public interest justification. And they say that the respondents, the claimants, could not afford to litigate without the additional liabilities. Our response is that the respondents' submissions are wrong in principle, and they're wrong in principle essentially for the reasons given by Mr. Justice Mann in his judgment. It's paragraphs 23 to 24. If your lordships go to the core volume, volume 3, it's tab number, well, it's at the back, tab number 2, and there's 2 2s, but it's the third 2. And the judgment begins at page 1030.
Tab 1013.
1030.
Thank you.
And your lordships will find the relevant passage at 1037. 1037, paragraph 23, where his lordship says that my friend Mr. Tomlinson's submission misses the point. It's inconsistent with the authorities. This is not a case in which a party resists the enforcement of a particular right because of its apparent contravention of Article 10. The Handyside is an example of such a case. The present case is an example of a situation in which a body of legislation as a whole is said to contravene Article 10. That was the point which the House of Lords thought was the correct point in Campbell, rejecting some sort of individual application of the article on the facts of the case. That was the point that was determined against the UK in MGN. And then there's a reference to the judgment of Judge Bratzer, a concurring judgment in Animal Defenders, to which I will return in a moment. And at 24, that's precisely the claim of MGN in the present case. It doesn't matter for these purposes that MGN has, at least in the 8 decided cases, been found guilty of conduct which, at least in some instances, can be characterised as criminal, and which generally it might be difficult to regard as responsible journalism. All that means at the end of the day is that its rights of freedom of expression were trumped by the privacy rights of the claimant on the facts of the case. That means that MGN lost, and if it had not lost, the point about additional liabilities would not arise anyway. When Lord Hoffman referred to information which ought to be published, he was not confining the debate about Article 10 and additional liabilities to such cases. He was suggesting how it was that the possible imposition of additional liabilities could dissuade a newspaper from publishing, thereby demonstrating as a matter of mechanics how it was that the question of additional liabilities came to be relevant to Article 10 in the first place. And the point was made by Lord Hoffman. I think your lordships have already seen it, but it may assist just to go back to volume 6, which I've lost. Volume 6 of the authorities. Campbell is at tab number 8, and the relevant passage is at page 2079.
Which bundle?
It's bundle 6, my lord. Bundle 6, tab 8. Campbell.
19 and 20.
And it's page 2079, paragraph 19 of the speech of Lord Hoffman. It's the last 3 lines. Can I pick it up there? On page 2079, it is true, says Lord Hoffman, that costs are awarded only against defendants who have been found to have wrongly published matter which is defamatory or in breach of a claimant's right to the confidentiality of personal information. So it may be said, and Ms. Campbell's counsel does say, that there's no harm in inhibiting such publications, but that, it seemed to his lordship, is not the point. It is the effect which the threat of heavy liability may have upon the conduct of a newspaper in deciding whether to publish information which ought to be published, but which carries a risk of legal proceedings against it. Then there's the reference to the Tolstoy case, the damages of 1.5 million. I'm sure the European Court said that they were excessive and disproportionate restrictions on freedom of expression. I'm sure, says Lord Hoffman, that they, the European Court, did not mean that people should be free to publish gross and deliberate libels. Then there's the Roman reference. The court was concerned with the indirect effect of a high level of damages awards upon the ordinary bona fide work of the media.
But isn't that a problem for you? These cases, Campbell and Tolstoy, the press bona fide acted but made a mistake and got it wrong. And if you penalise someone then, obviously that's going to affect their conduct across the board. In relation to other situations where they're acting bona fide, they will have to say, we might have got it wrong and we'll be mulcted. But in your case, it can hardly be said that you, if you engage in telephone tapping, that you bona fide believe that you're entitled to do that or to publish the result. And if the legislation and scheme had been focused on mala fide conduct, would it have been objectionable?
Yes, well, the point, my answer to your lordship is that the point that Lord Hoffman is making is that you cannot have a scheme which imposes additional liabilities because of the impact of that scheme on proper cases.
Yes, I mean, but
It's no answer to that, to say, well, yours is a case where you behave badly, any more than it would be an answer in Tolstoy to say, well, the publisher, Tolstoy, that was completely unjustified in what he did. It doesn't matter whether he acted in bad faith, negligently, or otherwise. The point is that if you have a system which allows, in that case, damages to be so large, it has an impact in proper cases. It affects...
Well, obviously, if the scheme applies to proper cases, then by definition, but that amounts, on your part, to saying that the mala fide can defend the bona fide.
Well, it's a submission that it is no answer to a complaint about a system which applies generally, that the particular case is a bad case. It's a case where the conduct of the press was unjustifiable. Otherwise, it means that the application of Article 10 depends not on whether the system is a proper system, but it depends on the particular facts and circumstances of the individual case. And that has a deterrent effect, because if that's really the law, then the press have to ask themselves, in each case, is there a risk that a court may take the view that we're an exception on the facts of this case to the general rule that you can't impose damages of £1.5 million, or you can't have additional liabilities, and that has a real deterrent effect.
If the rules applied simply to evidence obtained unlawfully, and where there was no bona fide defence, would they be objectionable?
Yes, my lord.
They still would be even then?
Yes, they would be objectionable for this reason, that it's not the purpose of the law through the civil system of costs to penalise. Your lordship is essentially putting to me that the civil law relating to costs should somehow, in press cases, and press cases alone, let's not forget, other than mesothelioma, that it should somehow be used to penalise criminal conduct. I mean, if we act in a criminally unlawful manner, the law has ample means of addressing that. It prosecutes. But it isn't...
Actually, an answer, because it's not enough, is it, for you to say this is an objectionable scheme. You've also got to show that the objections to it affect your rights under Article 10. Thus, in Coventry and Lawrence, the fact that the scheme might be objectionable in relation to other articles that weren't relevant, because it was an Article 6 case and not an Article 10 case, made a significant difference, might have been a critical difference. We didn't consider what the position would have been under Article 10. Now, the position here is that the gravamen of the complaint against you is not about publication at all. It's not about, so that the issue being considered in the extracts that you read us from Campbell about publication really don't arise because the gravamen of the case against you is that you hacked into people's phones. Now, assume that Article 10 is in principle engaged, which is probably supported by Haldeman and Switzerland, but the restriction is justified on the ground that the hacking is perfectly legitimately forbidden by law as an invasion of privacy. Why is the level of costs, why does that engage Article 10 if the conduct in question cannot be justified under Article 10?
Well, the conduct in question does include publication. It doesn't only include publication, but there were 3 complaints. This is set out in the Statement of Facts and Issues. If your lordships go to volume 3, tab 4, paragraph 15, it's page 923. The complaints made by... Volume 3, my lord. It's tab 4, it's page 923.
Right.
Paragraph 15, there were 3 complaints: listening in to voicemails on mobile phones, employing private investigators, and in all cases bar 1, I think that was Alan Yentob, publishing articles in the titles about the respondents which were based on the information so obtained. So it's not, with respect, correct to say that publication is not an issue. That's the first point.
No, I didn't say that. I said the gravamen of the case against you concerned the methods at which you had...
Well, the gravamen was the 3 objections, one of which was publication. That's the first point. The second point is that the purpose of the other gravamen to which objection was taken was that the information was being obtained for the purposes of possible publication. And therefore, in my submission, it's not right, with great respect, it's not right to say that this is outside the scope of Article 10. Article 10 doesn't only concern publication, it concerns conduct which is closely related.
Well, let us suppose that a claim was made against a newspaper which was limited to the fact that the claimant's house was burgled by a reporter with a view to obtaining interesting papers for the purpose of publication. Now, would your Article 10 rights make it improper to award the additional liabilities by way of costs when, after a trial in which the facts were contested, the judge found that that's what had happened?
And the newspaper was burgling the house of the individual in order to obtain information for possible publication. I mean, supposing that the newspaper believed that these papers demonstrated that the government was lying in Parliament about some essential matter of national policy.
Facts
Is that
that have no bearing on the current ones. Let's suppose that it was simply information about the claimant's sexual predilection for ladies that were not met his wife.
And one would have to ask, well, what about the facts? Supposing that the individual is the Prime Minister or the Foreign Secretary who has just given a speech in Parliament in which he says that it's the government's policy that marital fidelity should be encouraged and tax advantages given.
In which the sole cause of action alleged against you is you burgled my house.
Well, my answer to your lordship...
Article 10 is an answer to that.
Well, it could be, for the reasons I give your lordship,
right.
Yes. I do not accept, my answer to your lordship is I do not accept that Article 10 is irrelevant in those circumstances, and therefore I submit that if the newspaper loses the case, the additional liabilities fall foul of MGN because the system is a system that is inconsistent with Article 10, and it can have, as the European Court said, a deterrent effect on proper journalism.
Would your answer be the same if an individual who wanted to give the sort of information which you are supposing a newspaper might want to give, burgled somebody's house for that purpose? Or is it only the press to which your answer applies?
Well, the European Court has repeatedly stated that the press has a public watchdog role, which would not be enjoyed by me as an individual citizen if my objective is to hand documents to the Guardian or the Times or
Some might say that the privilege carries with it responsibilities.
Yes,
Those responsibilities could be reflected, it might be said, in a cost regime.
I entirely accept that those issues would be reflected in relation to the balance between Article 8 and Article 10 as to the substance. But what I can't accept, my Lord, is that it's appropriate somehow to build that into the question of whether, in principle, additional liabilities can be imposed.
That's when you look at it from the press's point of view, but one also has to look at it from the ease or difficulty of bringing proceedings against the person who, on this hypothesis, has been burgled.
Yes. Well, my answer to your Lordship in relation to that is that these matters were extensively looked at and reported on by Sir Brian Leveson. And the whole point of Sir Brian Leveson's analysis, his inquiry in his report, was to deal with allegations of very serious wrongdoing that breached the privacy of large numbers of individuals.
Yes.
And Sir Brian's conclusion was not that it is appropriate in bad cases to retain additional liabilities. On the contrary.
So do I take it you differ from Mr. Miller in an answer I think he gave to a question yesterday about whether if on the particular facts the court takes the view that there has been no imbalance on the particular facts of the sort identified in MGN and the UK, nonetheless you should still succeed.
My answer will be different. I'm coming to paragraph 218 in a moment.
I know, but I mean, I'm putting a point to you about what I think it was I who put to Mr. Miller.
Yeah, Mr. Miller accepted.
Yes.
The
And
facts
I take it you don't.
I don't, no, my Lord.
And you also, it's not merely the attack on the scheme, but you say nonetheless the same result should apply in relation to the particular relief that's accorded to you. Even if, on the facts, we think, viewed on its own, there was no infringement, if one just limits oneself to the facts, there was no infringement of your rights. It's because the scheme is objectionable.
I say the same remedies should be enjoyed. And I'm coming on, if I may, to
No, you may.
You'll be explaining why you say that, I trust, at some stage.
Will I explain? I'm sorry, my Lord.
You'll be explaining why you
Yes,
say that at
yes,
some stage.
yes, I am going to.
I'd like to hear that.
I'm just reminded by Mr. Carpenter that there's another answer that I should have given to the question put to me by my Lord Sumption, that is the burglary of the home and the claim that is brought consequent on that. Of course, if the claim is for burglary of the home, there are no additional liabilities under English law. The additional liabilities under current law only apply if it's a publication. No, it's a privacy case.
Well, except that your case is that this must be treated as a publication case.
Yes, but I'm entitled to have it one way or the other.
Only if necessary.
Lord, can I come on to the authorities in relation to this aspect of the...
Precise wording of the exception to the LASPO regime. It's publication and privacy, is it, or what's the phrase used?
Can I just go back to that? It's in volume 4. I'm sure it's a very good point. If we go back to... Yes, 10...
Publication and privacy proceedings, yes, which includes the misuse of private information, breach of confidence.
Yes, whether burglary of a house and criminal conduct of that sort falls within that is a nice question.
Is there a difference between criminal conduct involved in burgling a house and the criminal conduct involved in unlawfully hacking into somebody's emails?
Well, the purpose of the LASPO exception, I would submit, is to deal with publication cases. And once we're dealing with publication cases, then I'm entitled to answer my Lord's earlier question on the basis that the gravamen is that this is concerned with publication not merely because in these cases, in all but one case, Mr. Yentob, there were publications. There were no publications in Mr. Yentob's material because nothing was found that the newspapers wished to publish, but all of the information was sought for the purpose of possible publication. Now, the reason why the European Court takes the approach it does was explained, I submit, by Judge Bratzer in his concurring judgment in Animal Defenders, and your lordships will find Animal Defenders in volume 11 of the materials at tab number 3. Your lordships will recall this case. This is the case in which there was a challenge to the rule in the Broadcasting Act that there can be no political advertising on radio or television, and the appellate committee rejected that complaint under Article 10. And
By a short head.
well, the appellate committee was unanimous.
Yes, no, but
the European Court, by a very, very short head, rejected that complaint. And the concurring opinion of Judge Bratzer begins at 4367. For some reason in this report, it comes before the judgment of the European Court itself. No doubt someone has assessed it's far more valuable than the judgment of the European Court. And at 4367, at the bottom of the page, 01-4, Judge Bratzer says this: as in some other cases, the interference with the applicant's freedom of expression stemmed not from a decision or exercise of discretion of a court or executive authority, but from a statutory prohibition applicable in all forms of political advertising. Where the interference is the result of an individual decision, the court's approach has been to examine the necessity and proportionality of the restriction in the particular circumstances of the case. Where, however, as here, the interference springs directly from a statutory provision which prohibits or restricts the exercise of the convention right, the court's approach has tended to be different. In such a case, the court's focus is not on the circumstances of the individual applicant, although he must be affected by the legislation in order to claim to be a victim of its application. It is instead primarily on the question whether the legislature itself acted within its margin of appreciation and satisfied the requirements of necessity and proportionality when imposing the prohibition or restriction in question. There are, as the High Court and the House of Lords pointed out, numerous examples in the court's case law where the question of the necessity, proportionality and balance have been examined not in the context of the specific circumstances of the individual applicant, but in the context of the legislation itself, which was the source of the interference. And I would respectfully submit legislation must cover primary and secondary legislation. It can't matter whether it's primary legislation.
These are broad words. I mean, has tended to be different primarily on the question.
Yes.
So slightly fuzzy.
Nothing in Strasbourg, I accept, is completely absolute.
Not even when given by one judge, no.
No, indeed. But I respectfully submit it's helpful guidance from someone, a judge of enormous experience.
Here it's slightly more nuanced, isn't it? Because the precise extent to which the court has power to cut down the costs, including the two particular features that you object to, it does depend on the facts of the particular case. So it's not a purely bright line case, is it, looking at the bottom of page 4367?
Well, it's no part of our submission. I don't think it's any part of the respondent's submission to suggest that the court has some power to rewrite the scheme so as to...
I think it's got a right to rewrite the scheme, but it does have power over reasonableness of these various figures.
That is true, but not over the...
Not over the basic
aspects.
scheme, no.
No, and the basic scheme to which we object is the existence of additional liabilities. We cannot say to the taxing master, the taxing judge, that it's inappropriate for there to be additional liabilities. Additional liabilities are an essential part of the scheme. And this point, the point that you look at the scheme as a whole, you do not look at the specific circumstances, is in my submission the corollary of the principle which was stated by this court in Lawrence and in many other cases, that if the general scheme is proportionate, it is not enough for a claimant to show that hard cases can arise and that he or she is one of them. That's the general principle. It's Lawrence, paragraph 62 in my Lord the President and Lord Dyson's judgment. That's the well-established principle. You can't say this is a generally sensible or acceptable scheme, but it affects me in a particularly harsh way, and therefore there's a breach of the convention. And the corollary of that is that we are entitled, therefore, to challenge the general nature of the scheme, provided we're a victim of it, whether or not we are an attractive case, to put it bluntly. That's my submission.
I think to say you're entitled to challenge the general nature of the scheme, but what remedy you get if the challenge is successful may be a different question.
Well, I'm coming on to remedy, if I may. Well, can I deal with them separately and deal first with liability? Is there a breach of the convention? And then we need to go back, please, to what the European Court said in the MGN case, volume 12, tab number 3, and it's paragraphs 217 and 218.
Yep.
And at 217...
4864, yeah.
Yes, I'm sorry, Lord, 4864, thank you. Volume 12, tab 3, 4864, the second part of 217, the Court considers the depth and nature of the flaws in the system highlighted in convincing detail by the public consultation process and accepted in important respects by the Ministry are such that the Court can conclude that the impugned scheme exceeded even the broad margin of appreciation to be accorded to the State in respect of general measures pursuing social and economic interests. And all that has preceded that is an analysis of the system, by reference in particular to Sir Rupert Jackson's criticisms. And 218, this conclusion is indeed borne out by the facts of the present case. So the facts bear out, the facts of a particular case bear out the conclusion which the Court has itself already arrived at. And
Mr. Miller made that point.
Yes, and so I don't want to repeat it. And then at 219, in such circumstances, was disproportionate, etc., etc. So we do say, as a matter of liability, provided we're a victim, and we are, because we're going to have to pay these additional liabilities subject to the judgment of the Court, we therefore submit that there is liability. The question, the third question, to which I turn, is remedy. Now, we agree with my friends, Mr. Rampton and Mr. Miller, that the appropriate remedy is to apply Section 6.1 of the Human Rights Act, and that would take the form, in our case, I anticipate, of a declaration that a court has no power to order the payment of additional liabilities against the appellant. Now, is there some reason for us not to receive such a remedy? My Lord Sumption raised the question of legitimate expectations, in particular by reference to Section 8.1 of the Human...
It's really much broader than that, isn't it? It's simply whether one is not invited by Article 8, by Section 8 of the Act, to consider the justice of a particular remedy in the light not only of the right said to be invaded, but the impact on other parties.
Yes. Well, your Lordship then is putting to me that by reason of the bad conduct of my clients...
No. What I'm putting to you is that in deciding what is just, it may be necessary to take account not only of the question whether your Article 10 rights have been infringed, but of the impact of any particular remedy on other parties, in particular claimants who have made use of an existing legal scheme. Yes. Now, obviously I recognise that that raises the question of legitimate expectation, but I am suggesting to you that it's actually rather broader than that.
I understand. Well, can I seek to deal with the substance of it, whether one puts it under the heading of legitimate expectations through Section 8.1 or Section 8.1 generally? First, I make the point that all of the CFAs and ATE insurance policies in this case, the MGN case, were entered into by the respondents after the date of judgment in MGN and UK, each and every one of them. Your Lordships see that. I don't need to invite your Lordships to go to it, but it's Annex 1 to the Statement of Facts, sets out the dates. It's Volume 3, Tab 4, page 936. So I say each of the respondents knew, or ought to have known, that the arrangements into which they were entering could not, consistent with the Convention, if I'm right on liability, they could not, consistent with the Convention, lawfully impose obligations on MGN. And I respectfully submit that a person cannot have a legitimate expectation, if that's the way the case is being put. I appreciate it's broader than that, but one can't have a legitimate expectation that the court will impose an unlawful obligation on another person.
Well, that depends, doesn't it? There's an element of circularity about this. That depends, doesn't it, on whether it would be unlawful to exercise the discretion in relation to remedy under Section 8 in a manner which contravened your Article 10 rights. On the face of it, Section 6 is concerned with the substantive question whether there is a contravention, and Section 8 is concerned with the question whether justice requires that you do something about it, and if so, what?
Yeah. But Section 8 is no more, I would suggest, than a recognition of the general principle that a court has a discretion in the granting of remedies, a common law.
Well, it doesn't always. I mean, there's no discretion as to whether to award damages on a bulk standard tort. Some remedies are discretionary, some follow as a matter of course.
But an injunction is discretionary, a declaration is
discretionary remedies that we're concerned with here.
My submission is that the discretion which is conferred under Section 8 must be applied in a principled manner. It can't be for the court to say, well, we find under Section 6 that it would be unlawful under Section 6, read with the Convention, for the newspaper to be required to pay additional liabilities applying MGN, but we're not going to apply it in the circumstances of this case, unless there's some principled reason for doing so. I think I would accept that if the impact on the individual claimant is particularly unfair, harsh, onerous, then that may provide a basis.
Yes.
But my answer to your Lordship,
I think you accept the point I'm putting in principle, but say it shouldn't be applied in the present case.
No, and my first answer is that that argument doesn't get off the ground because there's nothing unusual or unfair from the point of the claimants when the world knew, and they should have known, since MGN and UK was decided, and indeed accepted by the United Kingdom government, that it was, to put it at its very lowest, very doubtful indeed, that this was an arrangement that could possibly be lawful under the human rights.
That depends, doesn't it, on whether somebody is entitled to take at face value a statutory order set out in the White Book until the government repeals it. I mean, the real problem in this case, as it was put, I think, yesterday, the question is who is going to be claiming damages against the UK government in Strasbourg. The government has, if your submissions are right, instituted a scheme which violates your rights. The question under Section 8 is, what are we going to do about that in a situation where a measure of injustice, a substantial measure of injustice, is involved, more or less whatever we do?
Well, can I then move on to the next answer to? I mean, I understand the difficulty the case poses, and I entirely accept that in substantial part it's the fault of the government because they haven't, although they accepted MGN in UK, they have not implemented it. They've not taken the steps that Sir Rupert Jackson, Sir Brian Leveson recommended that they could and should take. But I would also take issue, not merely because the claimants knew of MGN in UK. I also do not accept that the respondents in the circumstances of our case are suffering any detriment by reason of additional liabilities being unenforceable. First of all, 10 of the respondents have what is known as a CFA Light. That's Statement of Facts and Issues, Volume 3, Tab 4, page 924, paragraph 19. And a CFA Light means that they have no obligation to pay their lawyers more than is recovered on taxation. So in relation to those 10,
Understand the point.
There's no injustice to them.
Except possibly to the lawyers.
Yes, but the lawyers can hardly claim that their privacy rights are involved. I mean, their fees are involved, but perhaps given the bonanza nature of success fees, that isn't perhaps the strongest point that could be made. In relation to the other respondents, I respectfully submit it is inconceivable that the solicitors could or would pursue their clients for the additional liabilities if the sums are not ordered against the appellant. The respondents would have a very strong case that the solicitors should have advised them of the risk
Let's assume the risk point. To say that because they were aware of the risk, therefore forgetting what their solicitors may or may not do, it's just or not unjust on them to deprive them of the success fee and the ATE premium, even if they have to pay it. It slightly misses the point, surely, because inherent in the government introducing this scheme that's been considered by the European Court of Human Rights, is the government saying, without something like this, it's unfair on claimants. So one thing the claimant would be told is, yes, on your approach, is not simply the European Court of Human Rights has called this scheme into question, but that the government clearly thinks that some scheme is necessary to help you, and it may be replaced with another scheme. But what you're proposing is taking away everything and landing them with a cost regime which the government has made clear it considers it unfair to claimants.
Yes, but we're talking about the facts of these individual cases.
Yes, we are.
And the question is whether there would be some unfairness.
Well, so we're looking at the individual cases now, whereas before...
Well, that's what's being put to me.
Well, yes, I know it is.
On remedy.
But yes, but your case on remedy is one looks at the scheme as a whole. Don't look at the individual facts. Well, if we're looking at the individual facts...
Well, I'm happy
should.
I've made my submissions on the scheme.
I know.
And I have to deal also, because my Lord Sumption and my Lord Hodge have asked me also to deal with what is being put to me is the unfairness to the individuals in this case.
I might say, keeping your more helicopter vision, looking at the general situation, people in the position of claimants who proceeded on the basis that post-MGN in the UK, they can still be told, quite rightly, that the government thinks that the pre-99 scheme is unfair on claimants.
Well, dealing with the panoramic view and the fact that a scheme was thought to be necessary, the position of the post-MGN claimants cannot, in my submission, be any stronger than the position of Miss Campbell. I mean, she too entered into a success fee, which the European Court said was unlawful under the Convention. And the fact that a scheme was needed in general terms, not in her case, but a general scheme was needed to promote access to justice, and the government decided that was the best scheme, didn't stop the European Court from saying it's a breach of Article 10.
It didn't, but it didn't stop the European Court, as Lord Mance pointed out yesterday, deciding that in the circumstances of those figures, €97,000 was a sufficient compensation.
Yes, because that was an assessment in very difficult circumstances of the amount of the success fee.
Well, absolutely, but it wasn't by any means a full, as it were, return of what the success fee and ATE premium were.
I don't accept, with great respect, I don't accept much can be placed on that when the European Court said one can't work out what the success fee was. They were doing their best to provide a sum in respect of the success fee. But in relation to the individual circumstances, I say in relation to the respondents who do not have a CFA light, that there's only an unfairness to them if it is realistic to think...
No, I'm sorry to interrupt you. You're not right.
I'm not right.
In the second decision of the
Yes,
MGN
volume
case,
12, tab 2.
we can see the success fee was 279,000. That's page 4807.
Your Lordship takes that from what?
Page 4807, bundle 12, tab 3.
4807.
Page 4807. It's in the holding, I have to say. I haven't looked at the judgment, but I take it
But that's not what the European courts say when they come to look at the assessment of the amount that should be paid. If one
No, I know, but my point is that the success fee was 279,000. And they don't give anything like that by way of compensation.
But page 4807 is dealing with what was claimed. It's not dealing with the amount of the actual success fee. It's what's claimed. And the problem at 4802, tab 2, is that the European Court recognised that paragraphs 15 and 16, particularly at the end of 16, it would be speculative. But paragraph 15, end of 15, is a large amount of uncertainty as to the reasonableness of the base cost of the first appeal and consequently of the success fees calculated. So it isn't the case that the European Court is saying that the success fees are 279,000 and we'll only give you 79,000. It isn't their approach. They're saying we don't know and we're going to work out.
They're certainly saying they don't know because of the settlement.
Yes, precisely.
Look at the figures in 14. I think what's said against you is that although, of course, they've accepted that it can't be, because of the settlement, you can't work out exactly how much of the 500,000 is attributable to success fee. On any view, 97,000 euros can't possibly be other than only a bit of it.
Well, I respectfully submit it's very difficult to work out, contrary to the European Court's own statement at the end of paragraph 16, that they are somehow awarding only a proportion of the success fees, because they say at the end of 16 it would be speculative to assume the level, if any, at which a success fee could be considered proportional.
Precisely. How much there could have legitimately been by way of success fee.
Yes.
Yeah.
Yes. So I don't accept, with great respect, I don't accept that anything can be taken from this other than that it's a very rough and ready assessment which is not capable of scientific analysis. I was making the point, and I'm conscious of the time, I was making the point on remedy that there's only a detriment to these claimants, even the ones who do not have a CFA light, if, and only if, it's realistic to think they are going to be pursued by their lawyers who have already received or are going to receive the base costs that their lawyers are going to and would be able to pursue them for the success fees. The insurer will lose out if he doesn't get the insurance premium through additional liabilities, but the insurer has no Article 6 right to protect, and again he was perfectly capable of taking legal advice. One other point on liability, your lordships, I can't remember, I apologise, which of your lordships raised the point, but there was a concern about whether publishers who've already paid out additional liabilities could now seek to return to court out of time to recover those costs. This was a point raised. Was it my Lord Hughes? I'm grateful. And my answer is that in the field of criminal law, my Lord Hughes mentioned this, the most recent judgment of my Lord and Lord Torson for the court in the Queen and Joji, paragraph 100, 2016, 2 Weekly Law Report 681, made it clear that in criminal law, certainly, It's only in exceptional circumstances one can go back to the court on the basis that the law has been restated. A fortiori, I would say, in relation to civil law matters. Those are my submissions in relation to the third issue. That leaves the issue of estoppel. This arises only in relation to success fees, not ATE premiums, and it arises only in relation to the success fees of the 8 representative claimants, that is, the ones whose claims proceeded to trial for the assessment of damages. And the estoppel point arises because the respondents asked Mr. Justice Mann to award them a 10% uplift on their damages, and we, MGN, resisted that. We argued they were not entitled to a 10% uplift. And one sees the judgment of Mr. Justice Mann, the substantive judgment on this, in Volume 7 of the authorities. It's Volume 7, Tab 3, Gulati and MGN. This is the substantive judgment on remedies, on damages. Volume 7, Tab 3, page 2362. And the matter was dealt with by Mr. Justice Mann at paragraph 160. It's on page 2405. And at 160, his lordship says, this is a point which emerged in a casual, almost embarrassed way during Mr. Sherborne's reply. Mr. Sherborne, of course, was for the claimants. And there's a bit of authority. Mr. Sherborne, in passing, submitted that the 10% addition should apply in the present case. The point was not foreshadowed in any of the lengthy prior submissions. His lordship was left with a strong impression it had only just occurred to counsel. And at 162, there's a reference to the argument, to the written reply that was advanced, and MGN resisted this 10% uplift. We said it simply wasn't available. His lordship said, I can deal with the point shortly. It's quite plain from a reading of the decision in Simmons and Castle, it's volume 10, tab 5, if your lordship wants it, 3910, that the Court of Appeal intended an increase of 10% in damages for non-pecuniary loss as being a sort of substitute for the loss of the opportunity to claim CFA success fees, which was removed by section 44.5 of LASPO. And then there's some authority. Paragraph 50 is cited. Accordingly, we take the opportunity to declare with effect from 1st April the proper level of general damages in all civil claims will be 10% higher than previously unless the claimant falls within 44.6. And here, the claimant did fall within 44.6. 44.6 is the privacy and publication exception. Volume 4, tab 9, page 1097. And at 165, it's common ground. The claimants in this action have the benefit of CFA's. Mr. Nicklin's submissions, he was representing MGN, he accepted slightly ruefully that this litigation is of a class in which an uplift is still potentially recoverable, notwithstanding the LASPO reforms to allow them that benefit and uplift their damages by 10% would, in the words of the Court of Appeal, give them both the penny and the bun. And the estoppel point that's taken against us is that we should have said, well, you're not entitled to a success fee because of MGN and UK. That's the point that's taken against us. Therefore, we are now estopped. If we're otherwise right, we're now estopped at this stage on an assessment of costs from taking the Article 10 point, to which my answer is that the claim for a 10% uplift was manifestly bad in law, as Mr. Justice Mann found, because of section 44.6. The claimant had no entitlement to a 10% uplift. Our failure to mention Article 10 at that stage is absolutely nothing to the point. And the estoppel argument that is raised by the respondents is purely opportunistic. And I say that for this reason, that if Mr. Justice Mann had acceded to the respondent's submission and he'd granted an additional 10% in damages, that would have amounted to about £170,000, perhaps slightly more. The success fees claims are in the region of, depends on detailed assessment, £4 million. It is quite inconceivable that if Mr. Justice Mann had accepted the 10% uplift, that the claimants, the respondents, would have accepted that they were thereby prevented from asserting the recoverability of success fees at the later stage. Estoppel is based on equity, it's based on fairness. In my submission, any detriment or unfairness to the representative claimants, if any, by reason of this alleged estoppel, would be more than adequately met by ordering that they should have a 10% uplift on their damages rather than us having to pay their success fees. But it's inconceivable that that's what they want. This point has no substance, in my submission, no substance whatsoever. My Lord, that takes me to 1 hour, 50 minutes precisely. Of course, I will deal with any other matters that the Court wishes me to seek to deal with, but unless I'm told Mr. Carpenter...
I think in fairness, Mr. Lord Panic, I think in fact you have another 10 minutes, but if you don't...
Well, unless there are other matters, I've
saying you should
tried
take it.
to
I'm very
keep so that your lordships don't get behind the schedule.
I'm very grateful to you. In fact, you had 1 hour 50 and the first 10 minutes were taken.
It's absolutely right.
I'm not encouraging you to. I'm not encouraging you to say any more. But if you, it's only fair.
I think
it's
I've
only
dealt
fair
with
to,
all the points that I want to deal with.
It's only fair to point out to you. You have another 10 minutes.
I'm grateful. Yes, Mr. Carpenter tells me that I may not have got across to your lordships that there's no unfairness in relation to ATE insurance, going back to the question of the remedy, and I was making the submission in relation to ATE insurance premium, maybe I took it a bit quickly, that the insurer under the policy has no right to claim it from the respondents unless it is recovered as an additional liability. That's volume 13, it's page 5722, about a third of the way down the page. So there's no unfairness to the respondents.
Page number, I'm so sorry.
Yes, it's volume 13, it's page 5722, about a third.
No right to ATE premium unless recovered.
Yes. Unless it's recovered as an additional liability.
Oh, right, sorry.
So the claimants, the respondents...
They're the fairly standard terms of ATE policies, aren't they? They're not entirely so, but mostly.
Mostly, and in this case they are. So it can't be said by the respondents that for a remedy to be granted to us, even if your lordships accept that in principle unfairness to them matters in this context, and there is potentially some unfairness. There's no unfairness in relation to the ATE premium. And I've made the points, I think, in relation to success fees, CFA Light, and other matters. But subject to any questions that your lordships may have, and which I can seek to answer, I have addressed all of the topics that I wish to address on behalf of MGN.
What sort of estoppel is this that's raised against you? I mean, it's an estoppel blowing hot and cold, but analytically it's
well,
what?
Mr. Justice Mann put it on the basis that it was an approbation case. If your lordships want to look at the judgment of Mr. Justice Mann, your lordships find it in volume 3 of the materials at the end. Yes, page 103.9, the estoppel point begins at paragraph 26. And if your lordships go to 1041, at paragraph 33, some 8 lines down, his lordship says this is plainly not issue estoppel in its strict sense. My friend Mr. Tomlinson relied on express newspapers. That case involved a newspaper adopting opposing positions in 2 different pieces of litigation. And Sir Nicholas Brown Wilkinson's judgment is cited for a general principle of general application, not possible to approbate and reprobate. And at 34, having relied on the availability of the recovery of CFA additional liabilities in this class of litigation, the defendant now seeks to rely on the absence of that recovery in the present application. This is a classic approbation and reprobation. It's an inconsistency which should not be allowed. But that's not what we said. What we did was we responded to a claim by Mr. Sherborne, presented at the last moment, that the principle in Castle should apply, and that the Court of Appeal's judgment entitled his clients to a 10% uplift. And the entitlement to a 10% uplift was expressly based by the Court of Appeal on whether the case fell within section 44.5, and it didn't. And that's the short answer to the case. It's nothing to the point whether or not...
44.5?
4.6.
Well, 44.6 excluded the...
Yes. Oh, I see.
But just, it's just simply a timing point, is it? 44.6?
44.6 is not a timing point. No, it's an exclusion of those cases in which Section 44 has not been brought into effect. And it's not been brought into effect in relation, as your lordships know, to publication and privacy cases. So there was no entitlement under Castle, which is linked to Section 44, to a 10% uplift.
This is LASBO, Section 44.
Yes.
Yes, this is quite a difficult section, but
No, I'm sorry, but I'm
No, don't worry.
confusing your lordship, but
Yeah.
it's LASBO. If your lordships want to
Yeah,
look
it's
again, it's in volume
1097.
4
Yep.
of the materials. LASPO volume 4 at tab number 9.
That's right. Yeah.
And the relevant provision is on page 1097.
That's it. Yeah.
And section 44, subsection 6, the amendment made by section 4, I'm sorry, I said 44.5, I meant 44.4. 44.6, the amendment made by subsection 4 does not prevent a costs order, including provision in relation to success fee payable by a person under a conditional fee agreement entered into before the day on which that subsection comes into force, the commencement day. And of course, it hasn't been brought into force in relation to publication and privacy cases.
And that you find in the commencement order.
Yes, number 5, I think it
So
is.
you were simply, saying, you weren't saying you say anything positive about what would result the other way around.
No, we weren't saying anything positive at all. We were simply submitting, in response to the last-minute application by Mr. Sherborne, that the decision of the Court of Appeal in Castle did not entitle his clients to a 10% uplift. We also make the point, if we need to, that the whole purpose of the 10% uplift was to compensate claimants for those cases in which their right to additional liabilities had been removed by LASPO. And the claimants can't have it both ways. They can't say they were prevented from getting a 10% uplift and they wish to recover the millions of pounds that is concerned with the additional liabilities. And if there is any unfairness, and there's not, let them have their 10% uplift in damages. They don't want that. They want the additional liabilities. And the additional liabilities, for all the reasons that I've submitted, they can't have because of Article 10. That's the argument.
But there wouldn't be any basis on which a court could say you have the extra 10%, because there isn't, you pointed out there isn't any jurisdiction, isn't that right?
Yeah. Well, the Court of Appeal created the jurisdiction. They created the jurisdiction.
So they could extend it.
The Court of Appeal said in Castle, we can go to it, not now, but your lordships can look at it. The Court of Appeal said because LASPO has removed success fees, claimants should now have a 10% uplift in damages. That was the basis and Mr. Sherborne said, well, I'd like 10% extra. And Mr. Justice Man says, well, you can't have it because LASPO has not been implemented in your case, and that is so.
But are you saying that if you were right and if we're with you so far, this court has power to add 10% to the damages now?
Well, I'm saying if your lordships are persuaded that there is some equity here, some estoppel here, and if your lordships are looking at the position as between the parties in the individual circumstances of the case, it would be manifestly unfair to my clients to adopt any other approach.
You say we could actually increase their damages now, do you?
Well, if the alternative is to say that because of estoppel arguments, we can't complain about the additional liabilities, we'd much rather pay 10% more.
Well, of course you would. I understand that.
And your lordships would have power.
Even I've got that.
The jurisdiction is an estoppel jurisdiction, is equity. And in my submission, your lordships would have ample power.
The logic of the newspaper's case is certainly not that having struck down the scheme, we should then say, as common law courts, we must make good by awarding everyone else 10% extra on their damages. And if we can't do that generally, I don't see how in this particular case, I mean, the logic of your case is that neither applied, neither the scheme nor the 10%. Full stop.
It may be the stronger point that I make is that the fact that the claimants are essentially complaining about the failure of a 10% uplift, which is minuscule compared to the success fees, demonstrates that there is absolutely nothing in their estoppel argument. There is no equity.
I've always wondered, I mean, I think I actually once won a case in front of a master on this point, so it's something that's lasted with me forever. But I've always wondered why equitable estoppel couldn't cater for cases where the detriment suffered is minuscule compared to the detriment which would result from holding someone to an estoppel.
There's Court of Appeal authority to the effect that the measure of the detriment is not the same as the measure of the consequences.
I've been waiting for a case to come to this court ever since.
There's an observation of Miss Justice Hoffman at first instance to support the view of my lord on this. He remembers cases he won in front of masters. I tend to remember the ones I lost.
Well, I'm glad I reserved that extra 10 minutes for the enlightenment that your lordships have provided. I'm very grateful.
You reserved it and we then took it over. But thank you very much.
Thank you very much.
Thank you, Lord Panic. Thank you. Mr. Carpenter. No much. Mr. Price.
My Lords, can I bring you back to the flood case?
Yes, I think
and
that's what your job is. Yeah.
To the more mundane topic of whether of the challenge to the order for base costs that the judge made. My learned friend's submission being that his success on a significant part, and of course we accept it as a significant part of his Reynolds defence, should have been reflected in the base costs order. And can I ask your lordships just to look at how the issues on this are put in the statement of facts and issues, where in volume 1 at tab 4, page 69.
Yep.
Paragraph 17
Yep.
and 1 and 2 are the ones that I'm going to draw attention to.
Yep.
Sorry, the page again, sorry.
It's page 69.
Thank you so much. Yep, I have it.
Tab 4, page 69.
Yeah, thank you.
The first two of the issues stated are the base cost issues, and the remainder of them go to additional liabilities. It's just worth looking at how the issues are put. The first one is whether, as the appellant contends, the costs order made by the judge constituted an unjustified interference with the right of freedom of expression and the public's right to receive information. Or, as we contend, then our position is put out, article then not engaged, or there was no unjustified interference. So that was the first issue. The only other issue is whether the Court of Appeal was wrong to hold that the appellant could have settled the action before the Reynolds trial, or at least offered to do so in respect to publications on which it lost without conceding the point on which it won, and on terms respecting its right to publish information up to the 5th of September. So those are the only two issues that have been drawn out for your lordships. Now, the first of them is based on Article 10, and the curiosity is, before your lordships leave the statement of facts and issues, if we go back to page 67,
Yes.
at paragraph 10,
Yes.
Helen's argument that the costs order amounts to a breach of Article 10 was not raised before the judge, or stated in the grounds of appeal for the application of the Court of Appeal. This is really something that's come up, we say, to try and find a point of law to bring an exercise of discretion into courts of appeal, and particularly the Supreme Court. And the point is a significant one, because if Article 10 is really, and the effect of Article 10 is really so significant in this case, if it has to be factored into the balancing exercise which CPR 44 requires, well, then the judge, the matter should have been brought to the attention of the judge, submissions made, and in particular submissions on how it is to be brought into the balancing exercise. But the fact is that that just simply didn't appear before the learned judge.
Is this a point? Are you saying that it's not open to the appellants to raise that point, at least in relation to the special point in this appeal? Why are you?
Well, the fact is that for one reason or another, your lordships are given leave for the point to be argued.
Maybe because there's a point of general importance, which is the common point in relation to all the three appeals, and it's a bit inconvenient sometimes to give partial permission.
Well,
but given that the point is here, are you, so we're clear, are you saying that in relation to this specific aspect of the appeal, the forgetting the Article 10, the attack on the whole system of recovery of success fees and ATE premiums, are you saying that when it comes to the exercise of the judge's discretion, Article 10 is not open to the appellants because it wasn't raised? Or are you saying we should simply allow for the fact that it wasn't raised before the judge?
Well, I think it goes quite a long way, because if this point is...
sorry, are you saying it's not open to them to raise the point, or are you simply saying we should bear it in mind that they didn't and therefore the judge didn't deal with it?
Well, I think you've driven to it. I'm saying that it's really not open to it, because the learned judge was never given...
Right, no, I understand that.
So it raises... it goes that far.
I just wanted to be sure that I knew how you were putting it. Thank you.
Shouldn't the learned judge have taken account of Article 10, or shouldn't she, of her own motion? I mean, isn't that what the Human Rights Act says?
Well, I haven't the slightest doubt that the learned judge had in mind, indeed it's quite apparent from her cost judgment that she did have in mind the importance of public interest journalism,
yes.
And all the rest of it. So, I mean, it was there in the background in her, and indeed Articles 10, 8 and 10 are actually mentioned in her judgment. I think it's paragraph 3. But so it was undoubtedly there. But
I mean, it does sound very artificial to divide the law into different bits and say issues of discretion, issues of Article 10, and all the more so if the judge actually adverted to both.
Yes. The difficulty is that if the point is now assumed an importance which is greater than it really deserves, because my learned friend needs a point of law to bring before your lordships. But
that's a slightly different point. But anyway, we have the point. But so we'll let you develop your argument. Yeah.
Yes. So your lordships, essentially, your lordships are asked to interfere with the judge's exercise of discretion. Your lordships very well know what the principles are,
And you would say we're interfering with a discretion which has been, the exercise of which has been franked by the Court of Appeal.
Yes, precisely so.
Point taken.
Of course, if one factors Article 10 into the equation, particularly if one's giving it decisive effects, one also has to factor Article 8 in.
Yes.
And quite how one does that factors these into a CPR 44.2 has not been explored. It's not clear to us how a judge who was doing the balancing exercise which CPR 44.2 requires is going to sort of superadd the Article 10, 8 or Article 10 considerations. So there it is. I mean, the bottom line is that, that we say that essentially the Article 10 point has been pushed as a method of stiffening your lordship's spines. Really, it's not a point of law on which the exercise of discretion can be overturned. The balance is to be found. The balance between these two articles is to be found within CPR 44.2. So what it boils down to, and this was clear from a learned friend's submissions, Mr. Rampton's submissions, is that the issue is, an issue that's already been looked at once by the Court of Appeal, was the learned judge's decision perverse? It's a curious point to find myself arguing in this court, but there it is. It's come here. The principal point that we make is that the judge's task was a balancing one, and there were four principal factors that the judge had to take into account. First of them was the outcome of the case, a damages award of £60,000, which Lord Justice Sharp described in the Court of Appeal at paragraph 37 of her judgment as a substantial award in the context of defamation, and it is. Defamation damages are relatively small these days. The damages judgment shows why an award of that size was made. 15,000 of it was an aggravated damages sum. Nobody has sought to challenge the damages judgment. It was a careful reserve judgment after a 2-day trial. So that's the first point, and the second point is the fact that the respondent achieved his aim and object in the proceedings, which was vindication. The learned judge accepted that vindication was what he was aiming at. This was not a money winning exercise. The learned friend made a point about whether vindication is divisible, and that he was not submitting that it was. Of course, everybody accepts that you don't get vindication, even if you could, in an abstract sense, be said to deserve it, if you don't win the action. So the entitlement to vindication, of course, arises in relation to those parts of the publication on which we succeeded. But the fact is that what the claimant wanted was vindication, and that is exactly what he got. It was carried on a relatively small numerical proportion of the publications, but vindication is precisely what he got. He cleared his name. So that's the second point. The third point, which is obviously central, is the fact that the Times newspapers won on a significant part of the case, comprising, as my learned friend points out, numerically, substantially the greater proportion of the publications sued on. That is my learned friend's principal point, but it's, as the Court of Appeal rightly observed, it's proper to characterize the learned judge's cost judgment as essentially the whole of it as a careful examination of the weight to be attached to that point. Can I just at this point deal with a point that I think Lord Mance raised yesterday, that the later website publications, or the distinction drawn between the earlier website, the print publication, the earlier website publication, and the later publications, the cut-off point, that that came in late. It is right that that point only appeared on the pleadings just over a month before the Reynolds trial. But the reason for that is apparent if your lordships look at the chronology in tab 4 of volume 1.
Mm-hmm. Which paragraph?
It's page 72.
Thank you.
One sees that the action is commenced. This is near the top of the page. The action is commenced on the 31st of May 2007, near the end of the limitation period. It's quite apparent that Mr. Flood waited until he had to sue before he did, the reason being that he was waiting for the outcome of the police inquiry before he did so. And then there was the defence, and on the 3rd of August the reply was filed. That was before the cut-off point. The cut-off point was the 4th of September, or the 5th of September, the date on which the result of the police inquiry became known. So the point only became a live one after the reply had already been served. Then one sees that on page 73 that the amended reply was served on the 5th of June 2009, raising the point, and that the Reynolds trial started on the 15th of July. But the point cannot possibly have come as any surprise to the Times, who must have known perfectly well that it was going to be raised, because clearly the position is directly within the Luchansky decision, the Luchansky decision being a claimant who was accused by the Times, by Times Newspapers Limited, of possibly being involved in crime. I think reasonable grounds for suspicion of crime. A Reynolds defence was run, but the article was left up on the website unqualified, and the Court of Appeal, headed by Lord Phillips, said, well, that couldn't possibly be responsible journalism, because by then the claimant had sued on it, and the defendant had not put in a defence of justification. So, I mean, this case fell obviously squarely within, in principle, within the Luchansky decision. And Times newspapers were extremely conscious of it, having been refused permission to bring it to this court and then having taken it to Strasbourg, where the European Court of Human Rights upheld the Court of Appeal. So that's the context in which what my learned friend calls a late amendment came up. In reality, it's perhaps a bit of an exaggeration to look at it in that way. So back to the four relevant factors that the judge was balancing. The third of them, the Times' victory on a substantial part of the case. And the fourth, which the judge placed a lot of weight on, is the parties' respective attitudes to settlement of the action. In a sense, this...
It remains the position, doesn't it? I mean, assume that you're right, that the Times ought to have realised as soon as they had failed to put the notice on the website that they were failing. Seems a bit of an odd assumption, but assume they ought to have done. I think you were suggesting they must have done, but that seems a bit odd, but assume they ought to have done. Still, there must have been not negligible costs in the preceding period. The whole of the pleadings had taken place, advice from counsel and so on. I suspect if we looked at the figures, we would be raising our eyebrows at the costs that were incurred by then.
I accept not negligible, because unfortunately in litigation costs are never negligible these days.
You would say fortunately, but...
Oh, well,
Sorry.
it depends on one's point of view.
The fact remains that you've been given the whole of those costs, which were in fact on a basis, incurred on a basis on which you lost.
I accept that, and if my learned friend had ever suggested to the judge, or indeed at any level, that he ought to have the costs up to the date of the cut-off point, he would have had a much stronger argument than he has. That was never suggested. The fight, understandably, was really about the costs of the Reynolds trial. Which, of course, is where the bulk of the costs were incurred. There might have been an argument about the costs of the justification defence if we've been looking at awarding the times the costs up to the cut-off point. And whether the court would have thought it right to reflect that. In fact, of course, the justification defence was a pretty significant part of it. And because the Reynolds defence and the justification defence were aimed at such similar things, on the one hand, that there were grounds for investigating, and on the other hand, that there was a public interest in reporting the investigation, that the cost could really be regarded as attributable to each. But I do accept that had my learned friend asked for a special order in relation to the pre-cut-off point costs, he would have had a much better run.
If picking up that point, sorry to pick up a point which really I've made you in different guise in relation to a different point. If we were to think that there was something in that point, which you very fairly accept there might be, is it open to us to consider making an order that reflects that point? Or if it hasn't been run so far, would it be inappropriate for us to consider it?
I don't see how the judge can be criticised for perversity if she has not responded to an argument that has not been raised before her.
My Lord, yes.
But given that the case is here, is it open to us?
Well,
certainly the judge can't be criticised.
We'd first of all have to set aside the judge's discretion.
Yes, exactly.
yes.
It's about exercising one of our own.
Exactly.
But
So you would say, picking up Lord Hodges' point, that it's not open to us because in order, and of course, with respect to Mr. Rampton's argument, he would say it's a big if, but if this was the only way her judgment could be attacked, we don't get to that point because it can't be attacked for that reason.
yes. I mean, the reality is that this point has never really come up. And
well, exactly. That's what the point I'm...
And Mr. Rampton hasn't brought it up and asked your lordship to do that. When one's looking at the parties' respective attitudes to settlement of the action, one is really looking at the question which the judge had to look at. Well, who was really responsible for the Reynolds trial having to take place at all, which is a matter for judgment? And of course, as part of that, one has to factor in the fact that the claimant ended up with over twice what he'd indicated at a fairly early stage that he was prepared to accept. So I've already said the judge's judgment, looked at properly, really, amounts to a careful examination of the weight to be attached to the learned friend's point. I've given the paragraph numbers in paragraph 11 of the case. I'm not going to take your lordships to through the relevant parts of the judgment, but the judgment really starts out by saying this is the question that we have to look at. If I can just just look at the criticism of the judge for having, as my learned friends puts it, succumbed to the convenience offered by the simple concept of winner or loser. And I think I ought to take your lordships to the Roach case, Roach against News Group. It's in volume 10 at tab 2, page 3849.
Thank you.
This was a case, a curious case in which the claimant, who was a very well-known Coronation Street actor, perhaps not terribly well-known, certainly very well-known, he brought an action against the Sun. The Sun paid into court £50,000, and the jury awarded £50,000.
Can you give me the page reference?
I'm so sorry, my lord. It's 3844 in tab 2 of volume 10. Tab 2, page 3844. Curious set of facts. 50,000 in court, and the jury awards 50,000, and the
25,000.
The claimant, perhaps rather optimistically, argued it succeeded before the judge that he should have the cost because he got an injunction. But it's the principle that is looked at by Sir Thomas Bingham that I want to take your lordships to.
Page
3849.
Thank you.
If one starting in the bottom half of the page where he says well, first of all, he sets out the relevant provisions of the rules of the Supreme Court. And then he says, near the bottom of the page, two principles habitually applied in exercising the discretion are of relevance. The first is that in the ordinary way, costs follow the event. This means that the winner of the action recovered his costs. In a simple case, this rule raises no problem, but more complex cases may arise in which it's necessary to investigate with some care who is really the winner and who is really the loser, as it's sometimes put, to identify the event which costs are to follow. And then the second principle is that about payments into court, and where the claimant does better, or one of the parties does better than a payment into court. And top of the next page, the rationale of the rule is obvious. If the plaintiff puts the defendant to the expense of a trial in order to recover no more than he could have recovered without a trial, he should compensate the defendant for the unnecessary expense to which he's been put. Well, both those principles are in play here.
The first principle is actually in the rules now, isn't it?
Yes, it is. Yes. Sir Thomas Bingham goes on to examine the question of who's the winner and who's the loser in a bit more detail at the bottom of page 3850.
Thank you.
He cites the Anglo-Cyprian case, which was a case of Mr. Justice Devlin's, where the claimant had claimed £2,028 and then amended to make an alternative claim for £52, and he got the £52 but didn't get the £2,028. Mr. Justice Devlin was considering whether that should carry the costs, and top of page 3851, it was in his view necessary to examine the facts of each particular case to ascertain the object or objects of the action, and then having looked again at two other cases. At the bottom of page 3851, Sir Thomas Bingham says this: the upshot of these cases is, in my judgment, clear. The judge must look closely at the facts of the particular case before him and ask who, as a matter of substance and reality, has won. Has the plaintiff won anything of value which he could not have won without fighting the action through to a finish? has the defendant substantially denied the plaintiff the prize which the plaintiff fought the action to win. In ordinary way, the plaintiff's failure in the present case to recover more than sum paid in court would have led to an order that he pay the costs. The trial had done him no more than he could have had without trial. And then one might just similar way of putting it in the judgment of Lord Justice Simon Brown, which I think I needn't take your lordships to. So trying to work out who's the winner and who's the loser is not always easy. And in particular, the question as to whether the claimant has beaten an offer, or indeed the defendant has beaten an offer, comes into the question as to who the winner and who the loser is. There's something of a balancing exercise in deciding who the winner and who the loser is. And the learned judge certainly didn't treat this as a straightforward or simple exercise in deciding who was the winner. If your lordship go to the costs judgment, volume 1, tab 6.
Which paragraph?
I think I'm going to where the conclusion,
166,
which
right.
is on page 166. And really the judgment comes at paragraph 23. Returning to the starting point on 167, I find that the aim of the claimant was to obtain vindication, and in that he succeeded. I take account of the fact that the defendant succeeded on a substantive issue in respect to publications protected by Reynolds. Against that, I balance the conduct of the defendant in robustly refusing to countenance any settlement of this action. It was not until August that there was any softening. All of this is relevant, but of considerable significance is the fact that any offer made by the defendant has been beaten by the award of damages. Having identified what I regard as the relevant considerations, I'm not persuaded there are good grounds for apart from the general rule. So it looks as if in ascertaining who was the winner and who was the loser, the learned judge didn't treat it as in any way as a straightforward matter. One doesn't find, if one goes back in the judgment, any previous position at which he's decided who the winner or the loser was. And in a case where as nuanced as this, the balancing exercise can either be done in trying to decide who the winner or the loser is, or having identified who, if anyone, was the winner, it can then take place thereafter, and it's possibly not a critically significant point. But we don't accept that the learned judge simply succumbed to the convenience of the winner and loser and said, well, the claimant has got what he wanted, so he's the winner. That is not the way in which the judgment seems to proceed.
She refers to the observations in the Fox Foundation
Yes.
case. That's on page, going back a couple of pages to 164, is it? The observation of Lord Justice Jackson that quoted towards the bottom of the page.
Well, she gave some significance to that and was right to do so. I mean, the Fox case was a case, I think, in which a personal injuries claimant had fairly narrowly beaten the payment in, but had very substantially exaggerated his claim. And Lord Justice Fox said that one needs to be cautious about departing from the principle. And there's no reason why the judge shouldn't have taken that into account in this case, provided that she exercised some care about deciding who the winner or the loser was. So, if I can, essentially, what one sees is, in the judge's judgment, one finds an exercise of fact and evaluation. and one requiring quite a knowledge of the background of the case. So can I now move to the vexed question of the settlement offers and whether the newspaper could have settled or offered to do so without conceding the point on which it won. I'm now on paragraph 17 of our case, page 109. There were 4 phases of settlement discussions in correspondence, either open or without prejudice save as to cost. The last one is less significant because it postdates the Reynolds trial. And I won't take your lordships to that correspondence, except to point out that at that stage it became apparent that the claimant was willing to accept £17,500 for damages. This correspondence clearly weighed very significantly with the judge, and so we need to look at it. The first of the phases was the one which my learned friend Mr. Rampton took you to. It was the only one to which he took you.
So he took us to bits of it. Yeah.
Yes.
Accepted, to be fair to him, accepted. It had to be read as a whole, of course.
Yes. So if I can just take your lordships back to that. This is in the appendix.
If you take it fairly quickly.
Yes,
because, bear in mind that we'll look at it in context. Just
I'm not going
identify, as Mr. Rampton helpfully did, the particular parts you rely on.
Yes. I'm not going to read it all out to you in extenso.
No. Well, if you just identify quite quickly the parts you rely on, that I think will be the most efficient use of
just if one starts with the page 171. This is a letter which of which Mr. Rampton read some parts.
Yes.
There are 2 points that I want to make on this letter, which my learned friend, I think, didn't make. The first is that this is clearly an offer to settle the whole action.
Yep.
One sees that in the first paragraph and in the paragraph at the bottom of the first page.
Thank you.
The second is that it comes with a threat to undermine the outcome of the police investigation, which has just been communicated to the Times, if settlement didn't take place. One sees that towards the end of the first paragraph.
Thank you.
Once again, the DPS has confirmed that the ISC insider was the informant. We will obviously have to... What the legal manager of the Times points out is that the police investigation failed to contact what they say was the key witness. And Mr. Brett says, well, if this doesn't settle, we'll have to go back to him.
What's wrong with that?
Well, I'm not particularly suggesting that there's anything wrong with it, but if that as you've seen, that didn't result in a settlement, and the main point about this is simply that it didn't end there.
Yes.
And the points I want to make on this correspondence, the phase 1 correspondence, is first, the Times was not offering to take the story down. This was all in the context that they were going to go on publishing the article.
Yes.
So essentially, they were offering terms on which they could continue to publish a story, which the claimant took very severe objection to, and they were. And thirdly, that the claimant didn't regard it as adequate to clear his name.
Yes. Can you just take us to the parts then which you rely on for that proposition, for any proposition you rely on? Yep.
To the parts of the correspondence?
Yep.
Well, it's. I think your lordship has seen it.
Right. Fine.
That
That's fine.
Yeah, I think Your Lordship's seen. I mean, it's quite apparent from our response that the claimant didn't think it was good enough what was being offered. Now, if it is of relevance and material or even more decisive as to who, if anyone, was the more reasonable at this stage, well, then one has to look at what all the judges who've looked at this, and there are a number of them, because this is not the first time I've made these submissions to a court, all of them have been critical of the newspaper and have regarded the claimant's stance as reasonable. I'll take this, I hope, as quickly as I can, but I think I must take Your Lordship to that so that Your Lordship see how it's been dealt with. The first of them was Mr. Justice Tugendhat.
Yes.
This is in tab 11.
Thank you.
Page 324.
Yes. Yep, paragraph.
Paragraph 233.
Thank you. Shall we read it?
Yes.
Yes, we will. Thank you.
He's there on the importance of web publications to reputation.
Yes. Yes, I see. So that's that goes, you say, to the reasonableness of.
Yes, but then if one goes forward to paragraph 244, page 326, each party was entitled to reject the form of words tendered by the other in correspondence. The parties to a dispute are not obliged to settle it. And then the last words of that paragraph, the claimant can't rely on the defendant's refusal to relieve him of the obligation, at least where the claimant's refusal is reasonable, as it was here. And then at page paragraph 249 on the next page, he reaches the same conclusion as the court did in Luchansky. The failure to remove the article from the website
cannot regard it as responsible.
Couldn't possibly responsible. Is not in the public interest, and it's not fair to him. So Mr. Justice Tugendhat regarded the claimant's stance as reasonable. The claimant lost a significant part of the realm.
Do we have that?
Yeah, but his position was not. His position was upheld by a court of appeal headed by my Lord Neuberger. So his position was not, even on that, was not unreasonable. Your Lordship came to this. If we can look at tab 15 now. Page 400.
Well, this is coloured by what the Supreme Court held was a mistaken view of the law, so I'm not sure that. But anyway, by all means, look at it. Yes.
Well, I'm not sure. I'm not sure that that's right, but it was a mistaken view of the law on the other part of the case. At this point, Your Lordship is on the later web publication, so Your Lordship
on more solid ground.
On more solid ground. If page 428.
Thank you.
Your Lordship, at paragraph 81, quotes what we've just looked at from Mr. Justice Tugendhat, and says the only qualification relates to the last sentence. The fact that the claimant's refusal is unreasonable will not normally be enough to justify the defendant doing nothing. The essential point is that it's for a defendant to decide on the appropriate course to take. As well as being contrary to principle, it seems to me to be literally adding insult to injury to enable a defendant to require a claimant, after new evidence has come to light, to agree a form of words to amend a publication which is defamatory of him, but against which he cannot protect himself in law, so as to ensure that he still cannot protect himself in law. The at this point in the correspondence, the claimant is facing a situation in which the Times are going to continue publishing the words complained of. The learned judge, in her damages judgment,
Yes.
spent some considerable time on this point.
Page.
If we go to tab 17, page from, she runs through the correspondence. She sets out large parts of the correspondence at pages 520 to 526. She summarises the newspaper's argument on it at paragraph 81, paragraph 81, page 428.
Sorry.
And
Where are we going?
528.
521.
I'm so sorry, I'm working from a different copy of the
Paragraph
It's 538.
paragraph 80.
18, 20?
81, did you say?
Under the heading reputation.
No, sorry, paragraph 61.
Right.
I finally caught up.
Right, that's
She
the bottom of
sets out
page
there
5343.
the defendant's case on this,
Yeah.
and she rejects it at paragraph 71 and following. It's possible to pursue journalism said to be in the public interest and demonstrate consideration for the subject whose reputation may suffer. The need for such consideration is particularly acute given the subject's lack of redress. That's where Reynolds' privilege has been found. Once it's known that this material which exonerates, in whole or in part, the subject of the journalistic investigation, consideration should be shown for the position of the subject by publishing exculpatory material.
Is this really paragraph 71 to 74?
Yes.
Do you want us to read that rather?
Paragraph 71, 74, and 78 and 79, if your lordship would just...
We'll do that. If you want to sit down while we read them, you're welcome to do so. Now, in giving this judgment, she hadn't seen, or had she seen, the correspondence we've been looking at a minute ago?
Yes, she had seen those letters, yes.
Had seen those
yes,
letters.
but those were open letters.
So, I mean, just examining, it would, her view of those letters was factored into her award of damages.
Yes, absolutely so.
So her view of the letters is part of her ratio.
Yes.
So her assessment of the letters is binding on the parties.
Well, I think the point is simply this, that because the matter had been fully examined in the damages trial, my learned friend, Mr. Rampton, simply didn't make this point on costs at all. That one sees in, I think it's paragraph 46 of Lord Justice Sharp's, Lady Justice Sharp's judgment. This submission was not repeated on costs. So the criticism of the judge for not having factored it into her costs judgment really fails. She considered the point very carefully. She had not proved favourable to it. And my learned friend, Mr. Rampton, unsurprisingly, didn't have another go on the very day on which she handed down her damages judgment. So, one way or another, the action did not settle at that point, and the publication continued in the Times without qualification. And one then has to look at the next phase, which again I think your lordships have looked at, which is the references, Volume 1, Tab 7, pages 53 to 54. I needn't ask your lordships to turn it up, because your lordships have seen it. It's the without prejudice save as to costs offer to accept damages of £25,000 for the whole publication, including the part that was later held to be protected by Reynolds' privilege, and the Times' response to it. Now, nobody suggests...
And that's page not 53 to 54, it's 188 to 9, isn't it, of the bundle?
I'm so sorry. Yeah,
internal numbering 53 to 40. Yeah.
I think that's right.
Fine.
In the I'm using.
That's all right. It doesn't matter. Just to make sure I've got the right page. Yeah, thank you.
The point about this is that we don't suggest, and we have never suggested, that in the light of the ultimate outcome of the Reynolds privilege defence, the Times should have accepted the offer at that time. My learned friend was, in a sense, knocking down a straw man. As it turned out, up to shortly before that time, the newspaper turned out to have a perfectly good defence. Of course, we don't suggest that they should have accepted that offer, which involved an apology, damages, and everything else, at that point. The only significance of it is that thereafter, the Times was well aware of what the claimant was seeking. The judge undoubtedly understood this, because if one goes to paragraph 20 of her costs judgment, which is at tab 6, page 166.
Yep.
As to the progress of the matter prior to the final hearing, I note the claimant, from November 2007, the claimant indicated willing to settle. Any offer has to be viewed in the circumstances prevailing at the time that it was made. In November 2007, the defendant had a valid Reynolds defence. That said, the response was bruising. So she fully understood that nobody was suggesting, and nor was she, that that offer was acceptable at the time that it was made, it wasn't. But lest anybody should think that that the Times didn't fully understand the significance of that offer, if your lordships go to tab 12 at page 343.
Yes.
This is the argument on costs before Mr. Justice Tugendhat following the Reynolds trial,
Yes.
at which Mr. Rampton was asking for the costs.
Yes.
And at the bottom of the page, Mr. Rampton says this, that has to be put in this context. The question is there a realistic prospect that a reasonable jury properly directed could award the claimant more than $25,000? This is a discussion of the offer. If he wins on the defence of justification, if the jury did award him more than that, then he would have an argument that he was entitled not just to the cost of that part of the trial, which is what Mr. Price, as I say earlier, was claiming he would, but to the whole cost of the action from the date this offer was made, 12th of November 2007. So the Times fully appreciated the significance of that offer, notwithstanding that nobody has ever suggested that it could or should have been accepted at the time. So moving then to the next phase of matters, because we're now moving past the cut-off date, the date at which the...
Well, can we just understand that? You were saying nobody has suggested it could or should have been accepted. Yeah, no, well, don't worry. Yeah.
Well, I don't know if Mr. Brampton was suggesting that. I very much
Well,
doubt
he,
it.
he accepts as an argument what counsel say at one point to assist their case. It's really, he doesn't say it's a good argument, he said it's an argument.
Yes. If we can then move to the tab 7, this is going beyond the letters that my learned friend took your lordships to. Tab 7 in volume 1.
Yes?
Page 192.
All right, thank you.
And this is a letter which I would ask your lordships to pay some attention to. And the important thing to have in mind
Yes.
here is its date.
Right?
It's a year after the cut-off date. In other words, it's a year after the continuing publication by the Times has ceased to be protected by Reynolds privilege.
Before you've raised the point? 9 months before you raised it?
Yes.
You'd always, as I understand it, pleaded the website publications.
Oh, yes. Yes. We hadn't, on the pace of the pleadings, by this stage, drawn the distinction.
Relied on the failure to correct. You hadn't, yeah.
That's correct. That's right. It is 9 months before the Reynolds trial took place, that having been in July 2009. And what this shows is how there was no way that there could be any negotiation or settlement. What has happened is that the Times has gone down to inspect documents which were made available on a disclosure order against the Independent Police Complaints Commission. And he says in the first paragraph that he's now got copies
Yes.
of all the documents.
Yes.
And he says in the second paragraph, I think it's worthwhile rehearsing some of the documents and evidence. And then he goes through some of it. And at the end, towards the end of that paragraph, he says, indeed, the Department of Professional Standards' failure to go back to the original informant and interview him or her and or other people at IS Global demonstrate that what the police did by way of investigating the allegations made by the ISC insider was less than useless. So this is rubbishing the police investigation. For example, the DPS signally failed to go back
But what does this go to for the purpose of your argument?
What it goes to is to show that the action could perfectly well have been settled at a fraction of the amount of damages.
I know, but what I want to know is why are you bothering with this passage?
Why I'm bothering with it is to show you that there was absolutely no way that the Times were even going to negotiate at this point.
Well,
As I understand it, controverting the suggestion made by Mr. Rampton that this was simply a mistake. They failed to qualify the website in time. You're saying it was a deliberate course of action, effectively. Which is what the judge found.
But the judge has already found that, and there's been no appeal, so I don't know why...
But it gives colour, does it not, to Mr. Justice Tugendhat's conclusion when he was asked about costs at page 371, that even if you had conceded Reynolds' point in relation to the printed publication, the Times would have run the trial in exactly the same, or near enough exactly the same way.
That is what he said.
That's what he said, and that's presumably because they were wanting to lead the same evidence in support of justification.
Well, and because their position was that the police investigation that had taken place was worse than useless.
Yes, but I mean, in the end, the point is, all they're offering in this letter is the opportunity to discontinue the proceedings.
That's right.
Isn't that really all you need from the point of view of saying this was quite quite insufficient as an offer.
Yes, I think it is, but I need two things from it. One is that the Times are becoming increasingly convinced, not merely that there were strong grounds to suspect that Mr. Flood was guilty of corruption, but that he actually was guilty of corruption.
Yeah, I understand that, but I mean...
And on that basis, if one goes to page 194, one can do it in one sentence. 3 lines into the penultimate paragraph, as you will have gathered, there is no conceivable chance of Times newspapers capitulating in this case, and if necessary, we'll face all.
They're giving the opportunity to throw his hand in, and they're saying they're going to fight. That's really the point. Yep.
Yes.
They're going to fight. I think, as I understand it, Mr. Price, your point is they're not only fighting on the justification of the report, they're showing distinct signs of intending to try to prove not merely that there was an investigation, but that the man was guilty.
Yes. And indeed, if one looks at the...
Again, that's
Which is a good deal more than the article had ever said.
It's all in the last. It's all in that penultimate paragraph, isn't it?
Well, it was yes, it's a good deal more, in fact, than Mr. Justice Tugendhat held that the article meant.
Which undermined the justification defence.
Yep. Okay, we got that.
It wasn't just that they were of a mind to try and prove this. If one looks at what the defence of justification actually said, and I can do this quite quickly, but I would just ask your lordship to go to the judge's damages judgment, which is at tab 17.
Yes.
And go to paragraph 9 of it. I'm afraid I haven't got a page number.
516.
Yep.
One sees the amendments that the newspaper made in May 2008. It was alleged that the claimant was in particular need of extra money. He'd increased his borrowings. That will invite the inference that this was because of his gambling habit. The allegation was linked to the original allegation that shortly thereafter, 7 payments totaling 20,000 had been made to Noah from the suspense account of Keith Hunter. The May 2000 amendments averred that the claimant's personal financial situation improved materially at the time of these payments. And then further amendments in June 2009 alleged that Mr. Berezovsky was arrested. The claimant played a significant role in the handling of that request. Mr. Hunter frequently bragged about having a contact within the extradition unit. Just before the Noah claimant started, the claimant and Mr. Hunter had meetings. First, it was alleged the claimant passed Mr. Hunter police intelligence about Mr. Berezovsky and so forth. The next bullet point, the claimant told Mr. Hunter to advise a particular named suspect as to how to avoid being sent to the UK. Advice clearly prejudicial to the chance of apprehending him. The claimant's number was to be included in an ISC invoice. So one sees that as the justification defence developed, it turned into not so much a grounds for investigating as, at the very least, strong grounds for suspicion. But it all collapsed when, in due course, the justification defence was abandoned.
Very well. Is that a convenient moment?
I think that may be a good moment.
Very much. We'll resume again at 2 o'clock. Thank you very much, Mr. Price. Court's now adjourned.